Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am
Welcome back to part 2. Last time, Mr. Magoo showed up to court representing himself on a resisting and obstructing charge, and it did not go smoothly. Today, he's back, still representing himself, and the judge is about to remind him, again, exactly what that means. He's chewing gum in court. He filed a writ of mandamus with the Michigan Court of Appeals, and somehow, there's still no hearing date on his own motion. Let's get into it.
That I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Quick legal breakdown on what he's actually facing. Resisting and obstructing a police officer in Michigan is not a simple misdemeanor. It's a high court misdemeanor, which means it carries up to 2 years in prison and a $2,000 fine. That puts it in the same punishment range as many felonies. The judge's warning about the great perils of self-representation isn't a formality. It's a genuine constitutional obligation. Courts are required to make sure defendants understand what they're walking into before waiving their right to counsel. Mr. Magoo has now heard this warning multiple times.
From your mouth.
Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth. And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying
Let's
he doesn't.
unpack what just happened here, because this is actually significant. Mr. Magoo filed a writ of mandamus with the Michigan Court of Appeals. A writ of mandamus is essentially a court order demanding a lower court or official do something they're legally required to do. He used it to allege the prosecutor violated Brady obligations, meaning they withheld evidence that could help his defense. Brady violations are serious, but the Court of Appeals already dismissed it. And now the prosecutor is pushing back, saying discovery is complete and the things Magoo claimed were withheld had already been denied by the trial court. He's fighting on multiple fronts simultaneously without a lawyer, and it's getting complicated fast.
The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is something the defendant cares to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response.
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion or the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
The judge just said it plainly. What you just said didn't make any sense. And she's right. Mr. Magoo started talking about exculpatory evidence, then pivoted mid-sentence, then apologized for wording, then explained his ultimate goal was to see the prosecution's evidence. That's not a discovery argument. That's just wanting a preliminary exam, which he already asked for. This is what happens when someone conflates legal strategy with legal procedure. They sound like they know the terms, but the concepts aren't connecting. Do you think he has a real case here? Or is this heading exactly where it looks like it's heading?
Second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
January 2nd, 2025. That's the date. Preliminary examination set in person at noon, with the motion to be heard the same day. The prosecutor says discovery is complete. The Court of Appeals already tosses mandamus. His own motion has no hearing date attached, and he's walking into a preliminary exam alone against a prosecutor with witnesses on a charge that carries up to 2 years. Part 3 is going to be something. Do you think Mr. Magoo has a path forward here, or has this already gotten away from him? Drop your prediction in the comments, and make sure you're subscribed so you don't miss what happens next.